Hello and welcome to this ARA webinar titled H-2A versus H-2B 101, What Your Business Needs to Know. Today's webinar will cover the ins and outs of both the H-2A and H-2B programs for employers. We will discuss the requirements, barriers to entry, and best practices for employers, including pertinent current events. As the labor landscape continues to pose challenges, more and more businesses are turning to H-2 visas to solve their shortages. Ensure you have the tools to be successful with these highly regulated programs. My name is Hunter Carpenter, Senior Director of Public Policy for ARA, and I'll introduce our webinar speaker in just a bit. But first, I'll go over a few housekeeping items so you know what to expect. Webinars are an important part of the ARA professional development pathway and provide a great opportunity for ARA member companies to help educate their employees. Today's webinar will be recorded and added to the member-only ARA dashboard section of the website. As a reminder, you can log into the member-only ARA dashboard to access past webinar recordings at any time. If you do not have an ARA login, please email info@aradc.org to set one up. Questions will be addressed at the end of the presentation, but you can type them into the chat panel or Q&A function at any time. So with that out of the way, I'm excited to introduce our speaker, Megan Wright of masLabor. As a background, masLabor is the national leader in comprehensive services to employers in the H-2A agricultural and H-2B non-agricultural programs, representing more clients in more industries and geographies than any other service provider. masLabor is thrilled to be working with ARA as a prospective partner to help navigate the complex filing and compliance processes of programs. This webinar provides an opportunity to get to know the program's services and, most importantly, how masLabor can be able to best support your business moving forward. Please note, while masLabor has a team of in-house counsel, they are considered non-attorney agents. Any items discussed today are not considered legal counsel. With us today is Megan Wright of masLabor. She's the Senior Director of Business Expansion, and she ensures each client is comfortable and confident with the H-2A program or H-2 programs prior to enrolling. She stays up on all of the regulatory and compliance requirements, which is an ever-moving target. While Megan focuses on the company's business development, communications, and public affairs functions, she enjoys staying on the road educating folks on how the H-2 visa can save their businesses. She most recently served in a government consulting role for Booz Allen Hamilton with the U.S. Department of Labor. Without further ado, I'll turn it over to you, Megan.
Thank you so much, Hunter. It's great to be here. And as you mentioned, I'm actually currently on the road in Pennsylvania right now, supporting a Landscape and Nursery Association. So apologize for any background noise. But again, thrilled to be able to present this webinar to ARA. Hope this is the first of many to come. And as Hunter mentioned, we are going to take a deep dive really into both the H-2 programs. And I want to do that today because even though you all are agriculturally adjacent, when we think about the program requirements and definitions and nuances, our friends in the federal government certainly don't make it straightforward. So I wanted to be sure that we cover both programs here this afternoon, so that way we can make sure we're making an informed decision on what might be the potential best fit. So we'll do that again by going through background and history. We'll talk about requirements. We'll talk about audits and investigations. So this is, again, a federal visa program, so always want to make sure you feel comfortable and confident from that perspective. And then we'll take a little bit of a look in terms of recruitment and onboarding. We, as you can imagine, get a lot of questions when it comes to worker quality, how to retain workers, how to make sure that they come back to you year over year. And then we'll certainly talk about current events. I'm sure everybody has the new administration on the mind and keeping a sort of tabs on what's been happening and how that might, in this case, affect the H-2 programs overall. I then, as Hunter mentioned, want to save time for your questions. They can be program related. If you want to ask operation specific questions, I welcome those. And then there is a lot of ongoing litigation within this space. So depending on timing, I will dive into that. But again, this will be posted and shared in terms of the presentation as well, because there are a lot of links and resources that I want to make sure are available to you. So without further ado, I'm going to go ahead and hop into the programs as a whole. So starting at the very beginning, the INA actually created the H-2 visa classification in 1952. And then fast forward to 86 with IRCA, or the Immigration Reform and Control Act, that really split these programs into two. And for the most part, what we still know of them today. And so with those two, we think about the H-2A program as designed for all temporary or seasonal agricultural labor needs. And on the flip side of that coin, we have the H-2B program. So also temporary and or seasonal. And then, of course, for non-agricultural labor needs. To take that a step further, and as I alluded there in the agenda slide, what is defined as agriculture is incredibly important when we think about the overall eligibility side of things. And so really for the program, we've got two sort of different definitions brought to us by the FLSA as well as the IRC. And so primary agriculture is, for the most part, what the lay person is going to think. You know, are you actually the farmer? Is the work taking place on your farm? Do you own, lease, or control the land where the work is taking place? It is the field preparation, it is the planting, it is the harvesting, all of those very sort of generic farming or agricultural activities. Where we might come more into play, or the folks of ARA from the ag side, it's probably going to be a little bit more on the secondary definition side. You know, what activities are still in support of the growing operation or incident to, and how you might be getting involved. There is another layer of complexity that we would probably want to explore here is, again, if you are not the farmer, meaning that it's not, these activities are not taking place on land, of course, that you own, lease, or control, but the activities themselves are still deemed agricultural in nature, you may actually qualify as what's called a farm labor contractor, which is what allows you to do those farming activities on a farm, again, that is not yours. And there are tons of layers that we would want to peel back. And yes, there is a little bit of some extra paperwork if you are, again, an FLC, a farm labor contractor. But that is probably a direction a lot of the members may have to go. And again, outside of that, why I really wanted to make sure we also covered the H-2B program is because, let's say, yes, you are supporting the ag industry. Yes, maybe some of the job duties that you might have labor needs for take place on the farm. But what about things that take place off of the farm? What if you have, you know, mechanical more job duties? What if you have manufacturing style job duties? What if you are, again, working with commodities that it's not considered that you owned sort of the growing operation holistically? If we fall outside of those categories, even though, again, we're ag adjacent or supporting the agricultural industry, you know, we may actually qualify for the non-ag H-2B program. So I think, as we talked about in the very beginning, really is operation or business specific. And we just welcome any and all questions, or of course, individualized conversations, just to make sure that, again, we're peeling back the applicable layers and setting you up for success just right off the bat from an eligibility standpoint. And now really the elephant in the room then, as I continue to allude that we might have to shift away from the agricultural H-2A program, is that the H-2B side of things is a capped program. What that means is that there are a finite number of H-2B visas that are made available every government fiscal year. And because of that, there is a little bit more strategy, there is a little bit more timing in terms of the process that we really have to think through, again, to make sure that we're setting you up for success. But the nuts and bolts of that really come down to that the H-2B program, again, follows the government fiscal year, which of course runs October 1st through September 30th. And the overarching amount of H-2B visas that are allocated each government fiscal year is just 66,000. And that 66,000 in turn is split into two halves of the fiscal year, depending on contract start dates. So not your entire contract period, and we'll talk about what it means to be either seasonal and or temporary and how long you can have the workers. But just note that if you have an overall labor need that would start October 1st through March 31st, you would apply for the first half of the fiscal year. Or if you had a labor need then in turn that started April 1st through the end of the fiscal year, you would apply for the second half of the H-2B visas for the government fiscal year. I think it goes without saying that the demand far, far, far exceeds the availability of those 66,000. And we'll talk about what that looks like and how we're currently combating that demand. But long story short, it comes through the appropriations process in what we call cap relief visas. So again, there are gives and takes to both programs, as we'll learn throughout this presentation, in terms of requirements, in terms of regulations. But at very, very surface level, keep in mind the H-2A program is uncapped. Of course, agricultural being a matter of national security, while the H-2B program or non-ag program has a very, very hard limit / finite number of the visas made available each government fiscal year. And so I do keep alluding to the fact that these programs are both temporary and or seasonal. Even those definitions have to be different between the two programs. But long story short, you can have these workers per occupation as well as per geography, meaning the area in which the work is taking place, up to 10 months out of the calendar year. So really we're thinking about, in order to prove my seasonality as a business, I need to be able to show at least 2 months of downtime or a slowdown in payroll and overall revenue. In H-2A, the seasonal sort of definitions can be broken down into those three categories: certain time of year, event or pattern, labor levels going through the roof. Again, keeping in mind that even if you're considered seasonal, you still have to be 10 months or less. Or maybe you have a temporary business, meaning that you're not a year-round operation with varying labor levels. You actually shut down during a certain time of year. Well, then you would have a temporary labor need, which is just fine. In H-2B, in turn, we are broken down into two different definitions, either seasonal or peak load. Peak load is more akin to the seasonal definition in H-2A, which again assumes that you have a year-round operation, but you have a peak in your labor needs, again, that account to 10 months or less. And so because of the overall visa cap, if you will, it also plays a part in the overall timing and process of how we get through the paperwork approval timeline. Again, very surface level, this is a federal visa program, but we still get the state involved. We're dealing with Department of Labor, we're dealing with USCIS. And so, as you can imagine, it is a bit of a lengthy paperwork process. When we think about the H-2B side, overarchingly, we recommend that we really need to sort of have these conversations and come to the table in terms of what is the best fit for your operation. I would say at least 180 days in advance, because really starting at that 150-day mark, and I mean 150 days in advance of your desired start date, aka when workers would physically start working at your operation, we begin the overall overall paperwork process with what's called your prevailing wage determination. And I'll talk about what that prevailing wage is and how that is ultimately calculated. But again, in H-2B, the true paperwork side of things, it takes about 150 days. So again, a lot of sort of homework and thinking ahead or being proactive is necessary with this program, coupled with the fact, again, that we're going to want to try and mitigate or be strategic with when these visas are most readily available. On the flip side of that coin, when we think about the H-2A process, it is not only more readily available, again, since there are an infinite number of H-2A visas, the filing process itself is also just shorter. Again, we still recommend that we give everything at least 120 days to make sure that nobody's feeling rushed or stressed as we're compiling all of the information and paperwork needed. But just keep in mind that the true nuts and bolts, again, of the process takes 75 days in a normal scenario. I say normal because first-time program users can actually qualify for what's called an emergency filing. No extra cost. It's just a little carve out, if you will, for first-time program users that allows us to shrink that down to 45 days. And so again, I think that's pretty impressive, dealing with multiple government agencies to be able to start the process and have workers arrive in as little as 45 days. Again, the asterisk there is if maybe we are what's called a farm labor contractor and there is some additional paperwork, we again would want to take a look at that. But overarchingly, best practice, H-2B, we need at least 180 days, H-2A, ideally 120, but it could certainly take much less. Switching gears a little bit now into the requirements of the programs. I think it's really important for employers to understand exactly what they might be on the hook for. One thing that we do have in terms of resources is what's called a compliance guide. Really sort of unveiling / defining what these requirements truly mean. And so for the purposes of today, we'll just get through what I like to consider the big ticket items, really the non-negotiables or maybe the monetary requirements that you are going to have to keep in mind if we want to consider the H-2 programs being a solution. And so we start with probably the one that goes without saying if we're thinking that the U.S. Department of Labor is in charge of the certifying process. They're clearly going to want to make sure that we're not discriminating against U.S. workers by participating in these programs. So what does that mean? It means that on both sides of the fence, we're going to need to engage in what they call positive U.S. recruitment. Again, we don't have to get too far into the weeds here, but what that means is that during the paperwork process and in H-2A, even into the contract timeline of things, meaning when your H-2A workers are even on site with you, as an employer, you need to be willing to hire a qualified, willing, available, and able U.S. or domestic worker. What that really means is that the U.S. worker needs to have your minimum skill requirements. They need to be agreeing to the terms of the H-2 contract. But again, if they come to you and they meet those requirements during this overall approval process, you absolutely have to interview them. And in that case, you would have to hire them on as well. The next big ticket item, of course, would be wages, and that does look different between each program. In the H-2A side, you are going to most likely be paying what's called the AWR. It stands for Adverse Effect Wage Rate, and it is a statewide dictated minimum wage for this program. Yes, there was a 2022 AWR rule that sort of put a monkey wrench into that sort of blanket statement. which basically says that if you have any job duties that take you out of what Department of Labor considers an agricultural occupation, you would not be paying that AWR or that statewide minimum wage for the ag program. You would be paying the occupational wage, the OEWS wage, for that particular job. Some common offenses, if you will, some common job occupations that take you outside of what DOL calls the Big Six or the six agricultural job codes would be supervisors, would be heavy tractor trailer drivers, would be construction workers. Maybe you need to build a new farm building. Previously, all of those would have fallen under the AWR. But now, again, if we need job duties that are falling outside of the purview of those six agricultural job codes, you would be paying the occupational wage. So again, that is usually a pretty big dollar difference per hour. Not to mention it's going to have wider implications on your operation, which we'll talk about in a subsequent slide. But just note there, you can see how sort of wide-ranging the AWR can be depending on the state. A lot of our southern states are on the lower end, as you can imagine. And of course, out west, we're seeing some of the higher wages. The highest, that $20.08, is actually Hawaii, but California, to put as an example, is $19.97. So basically at that $20 an hour mark as well. On the H-2B side, then, you're actually, in most cases, going to be paying what's called the prevailing wage. And the prevailing wage, I think, as far as the program goes, makes some good sense. The prevailing wage is literally a combination, if you will, of the job duties themselves, aka what are these workers doing, coupled with the counties in which the work is taking place. So again, it literally should be spot on to what you're used to paying, because again, it's looking at what are they doing and where are they doing it. So again, not something out of left field for your area. And so corresponding employment then, especially on the H-2A side, is where those increased wages or those occupational wages can usually have quite a big impact on your operation overall. Sort of the layman's definition of corresponding employment is basically we've got the AWR or the prevailing wage to protect the H-2 workers. We've got corresponding employment then in turn to protect US or domestic workers. In H-2A, it is incredibly, incredibly literal, which just means that if a domestic or a US worker does a single job duty listed on the H-2A contract, that US worker is eligible for that H-2A wage. So you can imagine maybe you need a heavy tractor trailer driver on the H-2A side, but you also want them doing some of your other more farm labor-esque job duties. Well, now if you have a US worker doing those farm labor job duties, never stepping foot behind the wheel, they are still in corresponding employment for that higher heavy tractor trailer driver wage because of those overlapping job duties. So you can imagine it is very, very, very important that we take a hard look at what your labor needs are. We take a hard look at what wages would be applicable then to those job duties. And then certainly you can segregate job duties based on wage. And maybe you want to say, okay, I'm going to carve out these particular job duties for my domestic workers. And then on the H-2A side, I'm going to be doing these. Again, keeping that separate so the overlap or the corresponding employment doesn't come into play. In H-2B, it's a little bit more lenient. Really, that is the H-2B worker in terms of looking at their job duties. The US side of things, or the domestic worker, would have to be doing substantially the same job. And there's also a couple of caveats there that corresponding employment does not include, aka incumbent employees with a full-time nature, or of course, if they are covered by a collective bargaining agreement. So again, not as dire on the H-2B side, but just keep in mind, if you have a domestic worker that is substantially doing the same job, they too would need to be making the prevailing wage. The biggest, I think, stumbling block for most folks on the H-2A side is that you do have to provide housing. Not only do you have to provide housing for free, but it also needs to be inspected by the state. So again, we always recommend to think of housing solutions as the first thing you do when considering the H-2A program. On the H-2B side, housing is not a requirement. However, we still have folks coming into the country potentially for the first time that wouldn't maybe know the first place to look for housing. So if as an employer you just wanted to take that extra step to provide a housing solution for the H-2B workers, you would then be allowed to deduct rent. So we actually do find that a lot of our employers go ahead and go that extra mile, knowing that they can recoup the funds spent, again, through those payroll deductions. Travel is something, again, that is very similar in the programs, but also a little bit different. Between both H-2A and H-2B, employers are responsible for inbound and outbound travel, aka getting them from their front door to your front door and then back home again at the end of the contract period. I think what some folks tend to forget is that this isn't just the literal transportation itself. It also includes a daily sustenance. It also includes potential motel stays if there's a consular stayover. So again, sort of all inclusive, if you will, inbound and outbound travel. We do recommend trying to pay or reimburse this back within the first week, if possible, of the workers arriving, just because there are some FLSA minimum wage implications if we don't do that. But as requirements by the program, it just needs to be reimbursed or paid back by the 50% point of the overall contract period. Now, prohibited fees are increasingly, I guess, more and more important in terms of really trying to educate and pay attention. If we have time to get into the appendix and talk about some of the ongoing litigation, probably make a little bit more sense as to why. But at the end of the day, H-2 workers are not allowed to pay out of pocket for consideration of employment. So I think what's very tricky about this is, culturally speaking, there might be some folks that say, hey, you trying to get an H-2 visa? Pay me and I'll get you on a list. So again, that is absolutely prohibited, and it's becoming more and more of a hot button topic within the overall H-2 space. I think the sort of take home here is that if it's ever found out that an employee, aka an H-2 worker, did pay, whether it's for their visa, whether it's for recruitment, whether it was to get on this magical list that undoubtedly does not exist, both you as the employer and the worker are on the hook from a liability perspective and can both be barred from the program. So again, really much, very much a best practice to make sure that worker facilitators, folks in these home countries, understand this, are continuing to educate workers, and just make sure again that there is no money trading hands for the worker in terms of their overall participation in the program. And then when we think, then you're like, okay, it's a lot of scary information, but what happens if I do participate? And what happens, when my workers come and they're fantastic? And I really want to make sure that we keep having these same folks year over year. Some of the clients that we work with here at the event where I currently am, we've been working with them for over 20 years. They're on their third generation of the same family. And so that is absolutely the goal slash purpose really of the these programs is to create that foundation, create your crew. And so we really do encourage repeat workers, build those relationships, have conversations before they leave to go home, provide them with positive feedback, ask them if they have friends or family that would like to participate moving forward. Really just make sure, again, that we're fostering that long-term sort of relationship as the goal, of course, for you and the operation, but for the workers as well. And so when we hear about recruitment challenges on the front end, we sort of want to dispel some of those myths. We get questions all the time about, can I request certain skills? Are they going to have past work experience? And that answer is absolutely yes, as long as we can, again, prove that the prior work experience or skills that you're asking for is commensurate with the job occupation overall. We can absolutely include that on the job order, just getting approved from a government standpoint. And then worker facilitators, for example, that we partner with in these home countries, they take your job description, they take your minimum skill requirements, and then recruit and screen based off of that. So yes, it is very important to have a clear job description and make sure that those minimum skill requirements are very well articulated with your agent or your worker facilitator. We do then also really recommend having a bit of a backup pool. You do, of course, have final hiring decision in the workers that you're inviting to come on contract with you. So we do recommend having a couple more in mind. Life is life. There might be some last minute changes or worker cancellation. So it's always important to have a backup pool. And then, of course, as we talked about, really making sure that you're working with a reputable worker facilitator, a reputable agent to make sure that we are very much up on any Department of Labor or Homeland Security guidelines to make sure that, again, we're following those rules, documenting accordingly, and help set you up for success. So let's just say everything has gone well. Everything is great. Workers are now on site. As you can imagine, the program is really just now getting started now that they're working for you. So for example, we provide all of our employers with all of the workplace training and knowledge needs. So for example, OSHA posters that you should have in the break room. But heat stress is definitely something that continues to come up time and again. There's a potential OSHA final rule out there for heat requirements. So I would just go ahead and start thinking about heat stress training. Of course, if you work with pesticides or you have any sort of more dangerous activities, absolutely ensure that you are providing worker protection standard trainings on site and really, again, make that part of your overall orientation process now and document that so we have, again, sort of good practices in place should you ever participate in the programs moving forward. Again, keep saying that this is a highly regulated federal program, so audits come hand in hand with that. And so we get questions all the time about what triggers an audit and how can I be more prepared. So I hate to say it, but number two there is usually the case. It is usually a random selection in terms of who's getting picked for an audit, but certainly a worker complaint or a documentation issue during the overall process, paperwork certification process can absolutely trigger that as well. Keep in mind that there are two different types of audits. A sort of paper audit, if you will, sort of all handled online through the ETA arm of Department of Labor, very much looking at recruitment efforts, wage records, housing inspection paperwork, and payroll information. But there is also the possibility of what's called a wage and hour audit, which is in person. Again, certainly something that you all should be aware of just as an employer to begin with. But does participating, in these programs maybe increase the chances of, excuse me, of those audits? Absolutely. Pardon me. And so what can we do to prepare ourselves for a potential audit? Goes without saying, digitize all of your paperwork from worker onboarding documents Again, keep records of your payroll, make sure everything is in one place. And why not conduct an internal audit with that information that's usually requested on the previous slide, just to make sure that if you have a bit of a data call, you know exactly where everything is. And then number three is also really important, I think, for the in-person style audits. Again, it's pretty funny to see how sometimes folks just might not be prepared. They might get nervous. An easy example of this would be, culturally speaking, some cultures leave eggs on the counter in their homes. That unfortunately does not meet OSHA standards. So have regular housing inspections. Let them know that that's not going to be okay if we have an in-person audit. Maybe it's something like, you know, who's your supervisor? And they accidentally point to someone who's similarly employed who just happens to sort of be a natural born leader. As I alluded, supervisor is one of those job duties that should very much have its own wage as well as own job order. So really basic items like that should be sort of discussed and practiced ahead of time. I will make a little plug in terms of masLabor. It is absolutely our job to educate our employers in terms of all of these compliance of requirements, as well as make sure that we're providing you then with all the tools to make that happen. Is it a checklist? Is it a compliance guide? Do we have best practices? All of the above? Absolutely, yes. And so I do leave us before we get into some of the more of the current event style tips and tricks here for the program with a couple of things to keep in mind based on some of the litigation that we've been seeing crop up. The worker protection rule is one from Department of Labor that actually recently got overturned, which was a huge win. Again, we'll talk about that in the litigation section. But just because that was overturned, we still really, really recommend from an HR perspective that we're paying still attention to some of these items. When it comes to disciplinary action, absolutely have a progressive disciplinary scheme in place. Absolutely document and retain said documentation if you do need to ever have any disciplinary action. Very clearly, this exists already, but do not ever retaliate or blacklist workers depending on the scenario. Again, goes back to disciplinary action. I should mention that these workers are your direct W-2 employees. You can absolutely terminate for cause. I just want to make the point that worker protection standards continue to increase. So we would, again, just really want there to be a paper trail. Even from an onboarding perspective, again, back to the digitizing of records, we really want to make sure that we are keeping track of all of our onboarding materials. And this is kind of a funny piece here. Some vendors are now advertising, you know, why not have your worker protection or your heat stress training on the bus while they're en route to you? Well, you know, they are a captive audience. So a lot of these buses do have TVs, but, you know, that might actually be compensable time. You know, did we document that? Is this something that we made, potentially not mandatory if again that's not compensable. So really just kind of thinking through some of these broader HR implications as the programs again continue to be a little bit more regulated. When it comes to, again, wages and payroll, all comes down to just making sure that we're documenting on pay statements. There are 8 items that you have to have on each pay stub. Again, something that we show you in our compliance guide, but something as small as not having your EIN number listed on the pay stub, which is one of those 8 items, is technically an infraction from a paperwork standpoint. And then, of course, if we are participating in the H-2A program, there are sometimes, depending on your state, of course, overtime implications. So again, making sure that you're having a conversation with your case manager, that we're taking a very in-depth look at your job duties, at your state requirements, to make sure that we're, again, not leaving any stone unturned in terms of some of the additional requirements that you may have. I alluded to this a little bit too about making sure that we are paying the full picture when it comes to inbound and outbound travel. So again, not just the bus or the airplane itself, but any consular stayover, a daily subsistence, and again, making sure that those items are accurate. For example, at the last piece there for meals and lodging, you do have the sort of the minimum flat rate is $15.88 a day. But if you happen to have some enterprising workers, if they keep some receipts, you actually can or slash have to reimburse up to $59 a day if they have those receipts on hand. So again, really making sure that we're leaving no stone unturned there in terms of accuracy. But again, something that your agent should absolutely help you with slash provide you with in terms of an individualized spreadsheet per worker. So now I'm going to kind of switch gears a little bit and talk about, again, kind of what's happening in 2025. Yes, those were all best practices, but now I'm going to talk a little bit more about some of these current events that we're seeing. I alluded to the fact that the AWR, or the adverse effect wage rate, is that statewide dictated minimum wage. What I didn't say, of course, is that it does change each year. That second link is actually the table to the right, so you can see what it was in 24, what it is in 25, and sort of that overall percentage change. For the most part, it's usually a bit of a hard pill to swallow. The AWR comes from the USDA Farm Labor Survey, which is very much a flawed system. And so, for example, some of the active litigation that's ongoing right now is actually cases against that 2022 AWR rule to actually have either a freeze or at least to change the methodology. And so I hope everybody crosses their fingers on February 27th, where we're hearing the oral arguments by the federal district judge in Tampa, again on the 27th. So hoping for some positive news there. But the takeaway is, of course, that the AWR changes every year, and it is usually effective immediately as soon as it is published. Again, when we think about the H-2B program, if there happens to be anybody who is currently participating in that on the call, I wanted to give a little bit of an update here. Again, I alluded to the fact that there are those 66,000 normal, if you will, H-2B visas that are allocated every government fiscal year. We've made it very clear that that is not enough. And so each year through the appropriations process, they slap a Band-Aid on the problem. We certainly need overarching program reform, which is something that we are working very, very, very hard with the new Trump team on. But long story short, we get cap relief visas allocated each year. They are split into sort of two overarching buckets or categories, if you will. One, for what's considered a returning worker, meaning has that worker not necessarily come to your operation, but have they held an H-2B visa at least once within the past 3 fiscal years? Or are they coming from what's called an NCA country, which is listed out there? And there is, again, a very large bucket of those visas available. And so the returning worker visas are split into 2 halves, meaning there's an allotment for the first half of the fiscal year, which again, from a paperwork perspective, we've already blown by when we think about how far in advance that we work. And so there were 20,716 returning worker visas for those first half fiscal year 25 dates. Now we're taking a look at the second half, meaning again, from a paperwork paperwork perspective, we've already are looking at April 1st dates and beyond. And so from those results, we've got 19,000 returning worker visas to work with. And at this point, we've gone through about 5,000-ish NCA visas, so about 15,000 of those remaining. And so if you want to say, okay, well, all of this sounds great, give me an example of how many people are actually applying for this program, which is what you see here right now. So overarchingly, for folks literally just applying for the April 1st start date, they are applying for 149,953 workers out of what, again, is not even that 33,000 plus this Band-Aid or the cap relief visa. So 4.5 times the available visas under that initial cap. And again, the joke here is that that 33,000 is supposed to last the entire half of the fiscal year, let alone the demand being 4.5 times that for the first day of the second half of the fiscal year. And so again, very much need overarching program reform. But this slide kind of shows you the breakdown of how Department of Labor deals with that incredible demand for that April 1st or the second half of the government fiscal year. If you've had anybody that's participated in H-2B, or if you have before, I'm sure you've heard of the doomed lottery, or that term, the lottery. What it basically means is, as of 2019, they needed a way to sift through in a fair manner all of the paperwork that lands on Department of Labor's desk for that start date. So anyone who applies for an April 1st start date gets randomly, and it is truly random, assigned a lottery group letter. That letter, in turn, dictates the order in which Department of Labor processes your paperwork. So again, there is a lot of weight placed on what lottery group letter you get. And you can see the breakdown here on the slide of how many, that middle column there is how many petitions were filed, not number of workers, but how many petitions or job orders were filed and how they got sort of allocated. Usually there is about 25% that gets Group A, which means you are off to the races. Your workers are arriving on time, April 1st. Congratulations. Usually Group B also gets through on that initial 33,000 normal H-2B visas. But essentially Group C through G, you are reliant on those Band-Aid visas. And again, for the most part, we see folks really do continue to participate in this program. So if you are in groups C and D, you will have access to those 19,000 returning worker visas, meaning the same folks, again, that you've brought in the past. You can pull from that particular category of the Band-Aid visas. We did see a very, very small part of Group E also be able to scrape in on that 19,000 allocation. But for folks that are either new to the program or then fall outside of Group C and D and that little bit of E, you have some limited options. Your options would be going ahead and recruiting from those Northern Central America countries, again, using that 20,000 allotment of Band-Aid visas, which is usually what we recommend for new program users. Or there are some other cap mitigation strategies, some as aggressive as withdrawing your application altogether and doing what we call the October strategy, which is really gaming the system to try and get your foot in the door and ultimately resetting the clock for the next or the following season. Again, if anybody is either already participating in the H-2B program or thinking about it, depending on your operation, we can dive into all of those different mitigation strategies and what would be the best fit for your particular business. But moving forward here, I'm sure everybody has some questions or some thoughts on Trump 2.0 with the new administration. taking a look back at his first administration, overarchingly, it was generally supportive of the H-2 programs. I think it's always important to note that Trump himself participates in both H-2 programs. At Mar-a-Lago, he uses H-2B workers. And while it is primarily Eric still in the Trump family, they use H-2A workers at the Trump winery in Virginia. So he is very much aware of what the programs are, and we have done a lot of due diligence with the Trump transition team and now some of the confirmed members of the cabinet moving forward. But again, overarchingly, we saw some decent pros first time around, and now as the border continues to be one of their main priorities, really using the narrative that this is a solution to our advantage. And so it did go ahead and throw the cabinet up in here. Green, of course, means already confirmed. It has been interesting for us to see, again, just thinking about the program here, the pushback that Lori Chavez has, who is, of course, tapped for the Secretary of Labor, Department of Labor. She, of course, has been deemed a little bit too much in bed with the unions, labor unions, which, of course, is not necessarily a friend on the right-hand side, so facing a little bit of pushback. But believe it or not, she has actually been known to be very favorable to the H-2 program, specifically H-2A out west where she is from. So even though she, again, has a little bit of that union friendliness, believe it or not, she is actually a friend, again, to the H-2 programs overall. So we'll have to continue to keep an eye on this. Again, very much at the top of the news chain is all of the defunding efforts that we're seeing take place through DOGE. The USAID defunding, believe it or not, has a very interesting impact on the H-2 programs. Primarily, USAID has fully gotten in bed with the labor ministries in most of those Northern Central America countries, which clearly are big participants in the H-2 visas. What this means is that from a consular processing and recruitment standpoint, there might be a little bit of a slowdown. On our end, though, however, we've already sort of seen through some of the veiling that the labor ministries have presented and already work with what we consider private worker facilitators in those NCA countries. So again, we are not necessarily facing those same slowdowns, but very interesting to see how something like USAID defunding actually can affect something, again, as nuanced as the H-2 programs. Even since you putting these slides together, of course, Marco Rubio, Secretary of State, actually had a meeting with El Salvador and some of their labor ministries and talked about, again, the importance of their country's participation and can we get a waiver? And it sounds like those meetings already were positive. So as some of these activities get absorbed into the State Department, we'll continue to see how that might actually affect, again, these H-2 programs specifically. Again, at the top of everyone's mind are ICE raids. Again, it can be incredibly heartbreaking or frustrating if you maybe have long-term workers who might have provided you with documentation but may or may not be here legally. There really is no way to sort of right that ship if they, again, are not here on a legal status. There's no way to necessarily send them home and try and set things straight. But I do really want to reiterate here, and I will even on subsequent slides, that H-2 workers absolutely have a lawful presence in the United States as non-immigrant visa holders. So that being said, there might be misunderstandings, there might be miscommunications. We might need to kind of keep in mind that law enforcement may not be familiar with the H-2 programs overall. So there are definite best practices that we recommend to help combat these raids. So number one, always making sure that your workers have possession of copies of their legal documents, their passport, their visa, and carrying those copies with them, especially if they leave the work site. We do also have making sure that they have an emergency point of contact that can be reached at any time. We have a link there to actually create a sample letter that they can carry with them as well, attesting to their legal status. We also have a Know Your Rights card translated in Spanish and English that the workers can carry with them again. And this is all just to mitigate any potential unsurety in terms of the workers, but even to make sure that if anything were to happen, they have the tools to show again that they are here legally. All that being said, we actually are making positive progress again from an H-2 specific lens in terms of overall education, showing that, believe it or not, even on the right side of things, meaning Republican side of things, that is overarching support for the H-2 programs, and in these charts specifically the H-2B program. We even have Tom Homan on the record saying that the H-2B program is a potential solution to the border crisis. So again, really kind of reiterating that narrative that not only are these programs a solution, but again, in H-2B specifically, we need to think about an overarching program fix. As I've made clear that, there are not enough visas to go around. And so if more and more folks start to turn towards these programs, we need to make sure that we actually have a program that can, again, fulfill the demand that's out there. And so Steve Moore, again, who's a Trump advisor, we recently just had a meeting with last week, and he's working very, very diligently with President Trump on an H-2B fix. Something that we've been advocating for, I'll actually be personally in DC next week, is what's called a certified employer exemption, which would mean that if you've participated in the program for 5 years or are working towards 5 years in the program, you would automatically be granted the maximum number of visas that you've been certified for, and have those not count towards the cap. Meaning, again, you would be guaranteed that maximum number each year that you participate in the program moving forward. So it would be a huge win in terms of, again, making those visas just go further. But as I mentioned, being in DC next week, it is so important to advocate. I know ARA does a lot of advocacy work and does a lot of meetings on the Hill to try and, of course, further the association's goals. But these programs, as we've sort of touched on, are so important to the industries as a whole, whether it is agricultural directly or indirectly. So we really do hope and wish that you do also continue advocating on behalf of these programs, because as we all know, there can never be too much education with what we know and hold so dear, but that doesn't necessarily mean our elected officials are as up to speed as we are. So certainly getting involved is something I might leave you with. And so I would like to, since we are a little bit short on time, take any and all questions that you might have. And then, of course, I have an appendix that can just be shared out if you're curious about any ongoing litigation.
Thanks, Megan, for a great presentation. We do have a couple minutes for questions, so feel free to type those into the chat or Q&A functions. I'll be monitoring those. While we wait for the wheels to be turning and people to send in questions, I'll kick us off. Labor is obviously on everybody's mind right now, as you've stated, and we have our fly-in coming up in a couple of weeks. So one of the white papers that we've put together for congressional staff is on labor issues, And at the top of those lists in our requests to Congress are three, well, really seven bullet points, but three of the main ones are one, asking for a streamlining of application processes for H-2 visas, enabling or better enabling year-round employment. So removing some of those seasonal requirements. And then three, increasing worker portability. So it allows the workers to move between approved employers without requiring new applications every time. Do you see one, and sorry for the loaded question, do you see the possibility of finding solutions for these three requests? And do they have to be made via congressional efforts, or can it be done at the executive level?
So it's a really good kind of two for question. I think one of the things that was very frustrating that we saw there was also in 2022 was a loaded year, a new program rule that came out that really changed what's called joint employment. Joint employment used to be, I think, one of the best things about the program, where again, as long as you were on the application together, you could freely share workers. And so that means maybe based on your season, you do 2 weeks here, then you work a week over here, or maybe you're part-time here, and then you go to this other employer. You wanted to share housing, you wanted to share payroll. It really was great. And that 2022 rule rescinded that. And so now joint employment is only available for part-time labor needs. So I do feel like that could be something that we could see. One of the pieces that I added in the litigation standpoint is we saw the Chevron deference be overturned last year, which actually was a huge win for us. Basically, what that means is that agencies were participating or enjoying way too much overreach in terms of their power. And what that did is that overturned it and said, you know, you are not the legislative body. You don't have the ability to make these sweeping rules. And so that's why we've actually seen some success in some of the recent litigation. So to answer the second half of that question, in theory, it does need to come from the legislative side of things, because this is, again, even though it's a non-immigrant program, it's written under larger immigration code that would have to be voted on. But again, I think Trump is really using, President Trump is using his sort of advocates in that space to, again, push for more streamlined pieces. And again, but to answer your question, I think true program reform would need to come through a piece of legislation.
Okay, I see a couple questions in the chat. I'm looking for the Know Your Rights card slide so I can place that link in the chat. I'll do so in just a second as soon as I find that. One question is if I need to hire, if you need to hire to start March 1st to the end of July, should you apply in the October to March window?
Oh boy, again, how much time do we have? So the quick answer to that is if you are open to the NCA countries, then a March 1st start date would be possible in the H-2B program. And the very quick reason for that is, as we've alluded, those normal visas, if you will, are actually for that entire first half of the fiscal year. But Department of Labor processes in order of start dates. So in theory, if you had a March 1st start date, you're getting in line between, behind people that have October, November, December, January, February start dates. So those normal visas are long gone, which means as a first-time program user, the only bucket left available to you would be those cap relief Band-Aid visas. And again, since you don't have access to returning workers, it would have to be NCA. There is one other small carve out, that October strategy, but we unfortunately don't have time to dive into that right now.
Another question. Yes, the slides and recording will be made available on the aradc.org website. We will be sure and send that out to all registered participants in today's webinar. Next question. What would be the top 3 reforms to the H-2A program that should take place to improve the program? Could these be done by the Department of Labor? Oh, Richard asked, or is legislation necessary? I see that. So you kind of answered that portion of it. There have been recommendations to move the H-2A program within USDA. Any thoughts on that recommendation?
Again, I think we actually do feel like the USDA cabinet pick again is a friend to the H2 programs, and so I think that would be beneficial. I do think seasonality is a big hurdle for a lot of folks. I can't think of anything more traditionally agricultural than a dairy farm, for example, but people drink milk 365 days out of the year, and so they inherently don't qualify. So I do think that changing seasonal requirements is very important. I do think maybe even subsidizing housing would make this, program a lot lower barrier of entry. Again, the wages are absolutely crippling. I mean, they keep going up in most cases, anywhere from 3 to 7% year over year. So that AWR freeze, or just the overall methodology change, is also very, very important. And again, it is a little bit tricky now because of the Chevron deference being overturned. These agencies now, again, it technically for better, don't have as much power. So again, I would think that true program reform would need to come from legislation.
Well, fantastic presentation today, Megan. Thanks to you and masLabor for all of your hard work. ARA is pleased to continue a conversation with masLabor moving forward, and we hope to find some places, some synergies where we can work together. That's about all the time we have for today. So thanks again to Megan for delivering a great presentation. Thanks to all of you who participated today, despite your busy schedules. Be sure to contact me, Hunter, at aradc.org with any labor questions you might have. And Megan's contact information is there on the screen if you wish to reach out to her directly. So thanks again, everyone, and hope you have a great week.
Thank you.